Bandung's Fate by Kevin Crowe, a chapter in Contingency in the Course of International Law from Oxford University Press. The chapter asks why the 1955 Bandung Conference changed international law so little in its moment, and why that very failure matters now. In April 1955, delegates from 29 newly independent Asian and African states met in Bandung, Indonesia, representing more than half of humanity. Their aim was an agenda for global economic and political cooperation that resisted colonialism and neocolonialism. The United States tried to prevent the conference. The Soviet Union tried to co-opt it. Crowe's argument is deliberately fatalistic. Bandung's anticlimactic impact was almost inevitable, its fate. The narrative of Bandung's significance in the West was constructed before the conference even began. By 1955, the course of international law had already been set at San Francisco and at Bretton Woods. The final communique welcomed development, preferred consensus over adversarial dispute settlement, and prohibited intervention without consent. It inspired the non-aligned movement, the new international economic order, and later, 12 scholarship. Yet 40 years on, the WTO's Marrakesh Agreement codified nearly everything Bandung's participants had feared, rules authored by the developed world, with exceptions carved out for everyone else. Why was Bandung's fate sealed? First, Richard Wright. The famous African-American novelist's account, The Color Curtain, dominated Western understanding of the conference. But Wright saw what he wanted to see, a rebuke of colonialism, and missed the participants' consensus-based, face-saving diplomacy. Crowe argues that any Western observer would likely have been just as wrong. Second, the newspapers. Before the conference, Asian papers debated solidarity, while excluded Western states debated exclusion. During it, the New York Times cast Bandung as capitalism's triumph and China's embarrassment. Der Spiegel saw only negative principles. Le Monde dismissed anti-colonialism as emotional, and therefore irrational. Public perception in the West, Crowe argues, was a determinant in the development of international law. Yet failure is not the end of the story. Bandung left a normative surplus, norms unveiled in 1955, but never codified. Two questions remain worth sustaining. Should the political ever have been separated from the economic and international law? And what would development as cooperation look like? Compensation for expropriation judged not by what is just, but by what the host state deems appropriate. The conclusion: ideology does not undermine international law, it is always embedded within it. Markets are political, claims to universality are special pleading for entrenched interests. Accepting this frees the legal imagination from false necessities. Bandung's life, long thought to be over, may have barely begun. Bandung's Fate by Kevin Crowe, in Contingency in the Course of International Law, Oxford University Press.